Hey, you guys, what's going on YouTube? This is Sean, and tonight we're going to dive right in. We're going to talk about contracts because I receive a lot of emails and comments, and in some of the groups that I'm in around the topic of staffing and recruitment, everybody's always asking, "Hey, you got a contract I can look at? Anybody got a contract? Anybody got a contract?" And no matter how many contracts people are given, people still have more questions about contracts. So before I get started, I just want to say that I am not a lawyer. This is not legal advice. This does not substitute for having your lawyer look at your contracts if you're making them yourself, or completely compose them for you if you're not making the contract yourself. Fun fact about me: I am a 2-time law school dropout. So back when I finished pharmacy school and got licensed as a pharmacist, I did that in the spring, April of a particular year, graduated, got licensed, and became a pharmacist. At the same time, I went into law school the following fall. So I guess I am a glutton for punishment because my dream was always actually to be a lawyer, not a pharmacist. And with some of the personal challenges I have faced in my life, it probably would have served me better to have been a lawyer. But I'm going to fix that because I'm getting ready to start studying for taking the LSAT again, which is the college admissions test for law school, so that I can go back to law school for the third time and maybe finish it. Another fun fact is that the first time I went to law school before dropping out, I had to take contract law. That's first semester of law school. And I ended up getting a B in that class. And I was kind of mad about that B because when I tell you I know contracts, I know contracts. I knew it very well, but I still ended up with a freaking B. But I still remember that information. So I'm going to utilize some of it today to explain contracts to you in terms of staffing and recruitment. And I'm hoping to break it down into the simplest terms so that you don't allow it to intimidate you anymore. Contracts can be as long as you want them to be, or they can be very, very simple if you understand at the fundamental level what a contract is. So, at the fundamental level, a contract is simply a legally binding agreement between two or more parties. It's a promise or a set of promises that, if need be, the law is going to enforce those promises. Okay. The purpose of a contract is to establish the terms by which the parties that are entering to this contract, to establish how they're going to interact with each other, how they're going to exchange goods or things, how they're going to exchange services, and any other valuable thing, any other, we call that consideration, valuable consideration. Ooh, I can't wait to get back to law school because I still know some of this stuff. So, the basic parts of a contract: you have an offer, which is where one person, one party of the contract, proposes an agreement under these specified set of terms that they're willing to agree to. So let's just say I am the party with the offer. I would draw up my contract. And I, of course, since I'm drawing it up, obviously I agree to the terms of my contract. And I am going to take that contract, that proposal, and I'm going to give it to somebody else. And I'm going to hopefully hope that they agree to it too, that they review it and they agree to it. And we enter into this set of promises that's made in this contract. The other part of a contract is the acceptance. So the other party must accept the terms without any modifications to that contract. What I learned in law school is that once you have a contract, nothing outside of the four corners, think of a document, a piece of paper, nothing outside of the four corners of that paper matters. Meaning that if I draw up a contract and I go to exchange that with the other party or the other parties, they cannot scratch through anything and write on it and sign it, and now their terms become the promise that we're going off of. No, that would actually be a counter offer. So that would be a whole nother contract, basically. So acceptance would mean that you accept my contract, the offer, as it stands. And it must be communicated clearly. It cannot be unclear as to what the terms of the contract are. That's why you end up with these more wordy, lengthy contracts, because they want to make sure that everything is in there, because there has to be offer and there has to be acceptance. Then there has to be consideration. This one is what messed a lot of people up and confused us in law school. Consideration. This refers to the value that is exchanged between the parties. It could be money. It could be services. In our case, we're doing both. We're exchanging money in exchange for services. We're getting money from the client in exchange for our candidate or our worker providing a service to them. We are, in fact, providing a service for them, the staffing part of it. Okay. So anything of value, money, services, whatever of value, both parties must contribute consideration. Both parties must contribute something of value in order for the contract to be enforceable. I wish I could think of a real quick example of something that's not consideration, but I'm not that prepared yet. But it has to be something tangible. It has to be something valuable. Okay. And I won't go too much further because I don't want to convolute the purpose of tonight. Now, this next part, this next element is my favorite. I will always remember this term. Once I learned it, honey, you couldn't get me up off of it. There must be mutual assent. Mutual assent literally means meeting of the minds. There must be an agreement between the parties. Mutual assent, meeting of the minds, means that all parties involved have to understand and agree to the basic terms of the contract. So there has to be an understanding of what's in the contract. If there's no understanding, there's no mutual agreement, then there is no mutual assent. Without mutual assent, the contract is not valid. Capacity. This is one that I see people throwing around social media all the time. Capacity. The parties must both have or all have the legal ability to enter into a contract. So that means they have to be of legal age. They have to be of sound mind. They can't be drunk. They cannot be there's another one, under duress, which means that they're being forced or intimidated into signing something. So there can't be duress or some outside influence that's impairing a person's judgment as to whether or not they should sign something, whether or not they should agree to something. So you have to have the capacity to enter into an agreement. Somebody that's 13 years old doesn't have the capacity to enter into an agreement with me. And then lastly, there has to be legality. The contract's purpose must be legal. You can't have a contract for the sale of illicit Schedule I drugs with no medicinal value. You can't go, I don't know what anybody's preferences are or extracurricular activities, but you can't go sue your drug dealer for your marijuana dealer. And in some places it's legal, but you still can't, for the most part, at the federal level or state. You cannot sue for any contract related to illegal purposes. A John can't sue a prostitute. And let me not get too graphic. it has to be legal. Whatever you're entering into a contract on, it has to be legal. Okay. So when all of these elements are present, then you have a contract. And a contract is powerful. Not to mention a contract can be verbal. That's another set of circumstances, but we're talking about a paper contract. There's another issue that comes up sometimes in court as to whether or not now the digital signatures we use, DocuSign and things these days to sign documents. Well, in some courts, it's been found that unless you have a wet signature, the contract might not be valid. For the purpose of this conversation, we're going to say it's valid because for the most part, you're going to be using DocuSign, PandaDoc to exchange these contracts. And once there is a contract in place, it is legally binding and it creates an obligation between the parties that can be enforced by law. Enforceability provides assurance for everybody. For your security and your assurance and mine, it's best to enter into a contract. This allows us to do our business transactions, our employment agreements, service provisions, and whatever with confidence that each of our interests are protected under the law. Okay, so that's my spiel. Let's get into the actual contract. So if you've seen this, if you've watched me before, you've seen this back office here. This is the Staffing and Recruitment Digital Toolkit. And again, it has 3 functionalities, whether you're starting your agency, operating your agency, or scaling your agency. There's something in it for everybody. So tonight we're going to go to the operations part of the toolkit because I would say that contracts are a part of operations. You're always going to be exchanging contracts at some point in this business. So once I open that up, I'm going to go to folder I, and it's the contract templates folder. Now, the funny thing about this folder is, as you can see, it's a bunch of contracts in there, a bunch of different kinds. And I did that for a reason, thinking that the more I included, the less questions there would be. Like, it's all kinds of contracts, so you'll be able to pull from different ones based off of what you need. Well, that's not what happened. It seems that the more contracts that are exchanged in the groups or, wherever, people get more and more confused because they feel like their contract should look just like everybody else's, when the actual point of me doing it this way was to show the variations in contracts. Like, there's a contract can be as simple as a paragraph or a sentence. Well, probably need about 3 sentences, but contract can be very simple and it can be very complex. It depends on the use case of said contract. So what I did was I added 2 more documents so that I can really get into this for you. So take some notes, screenshots, whatever you want to do. I'm going to do this one time, and then hopefully I won't get any emails about this contract stuff because don't make it hard. So the first document, if you have the digital toolkit, you have this. If you're in the mentorship group, you already have this. If you don't think you have it, go look for it and let me know. But understanding contracts as it pertains to staffing services. So in our staffing and recruitment business, you're typically going to have maybe 3 different types of contract. You're going to have the temporary employment contract, the temp to perm employment contract, and the direct placement agreement or direct placement contract. The first one is the temporary employment contract. The purpose of that contract is to hire an individual for a position that is only intended for a specified period of time, a limited period. So for example, a temp contract can be 1 day, it can be 3 months, it can be a year. I have seen contracts be longer than a year, but for the most part, we try to do it at a year. If it goes beyond a year, we will just do another contract and extend the contract. What's funny is today, and I'm trying to look it up, I got a contract that came across my desk for a pharmacist position, and it said 1.7 years is the contract terms. And I'm like, what do they mean 1.7 years? Do they mean 18 months? Do they mean a year and 7 months? Like what are they? What are the units for that? I've never seen it that way. Usually we write out the months or we write out the years, and we don't do 1.7 years because that can be interpreted a couple different ways. Um, like, are we multiplying a year by 1.7? I don't know. Anywho, I'll clarify that another time, but I thought that was funny. Temporary contract terms are just that, temporary. You define the start and end date of the temporary employment. The duties and responsibilities are there. Of course, the compensation. What is the payment structure for the duration of that contract? Termination specifies under what conditions that contract might end early. If you're in an at-will state, that contract can end for any reason at any time. They don't have to have a reason to not need somebody's services anymore. And then it probably has a confidentiality clause. I won't get into NDAs and all that stuff in the scope of this. We're going to keep it simple. That's a temporary employment contract. Then you have a temp to perm contract, which is just what it says. There is a temporary part of it, and then there's a transition to the permanent part of it. I have been in roles in my personal career as a pharmacist where I would go on through a temp company, and then at the 3-month mark, if I did a good job, they would convert me to an FTE, full-time employee. I used to love that. These days, I prefer to work contract basis. Actually, I don't even work contract basis personally. I only do corp to corp, which is another conversation for another day. But you have temp to perm employment contracts. And the purpose of this contract is used if you're initially hiring someone on a temporary basis. And then there could be a potential for an offer of permanent employment later on. And of course, you would have the terms of that, like under what circumstances would the permanent offer be made? What would be the compensation terms for temporary versus permanent? Out of the contract questions, I would say that this contract comes up the most because typically I see it a lot with our healthcare staffing folks, whether it be nurses, pharmacists, whatever, even engineers. Sometimes they come on a temp basis and then they get converted. So this is a very common type of employment contract, but it raises the most questions. Again, you would call out the termination terms, the details on how either party can end the relationship, and then confidentiality again. And then we have, lastly, the direct placement agreement or contract. The purpose of a direct placement contract is simply a contract between the recruitment agency, you or I, and the company where the agency is committed to finding candidates for direct permanent placement, direct permanent employment with the company. Let me say that again. Direct placement contracts are a contract between the recruitment agency and our client, the company, where we, the agency, commits to finding candidates for direct permanent employment with the client, with the company. So the components of this agreement: service provided. So you would have a list of roles and the duties and qualifications of those roles. Fees and payment breaks down what we're charging. What is our percentage? What is our markup? The guarantee. The guarantee is an offer that remedies if the candidate doesn't fit. What does that mean? Typically with direct placements, we give anywhere from 30 to 90 days guarantee. So if that person, for whatever reason, is let go or doesn't stay for 30 to 90 days, whatever's called out in your agreement, what are we going to do about it? What are we offering the client? Are we going to replace the person? Are we going to refund them? That needs to be stipulated in the contract. Of course, there's confidentiality again, which protects the candidate's information as well as the company's information. And then there is an indemnification clause, which also protects the parties from any potential damages. Now, the indemnification clause can also be in the temporary and temp to perm contracts. And that can be for any host of reasons. But indemnification, that can be in any of the contracts. All right. And then within these contracts, you would have exhibits or schedules or detailed breakdowns of what the specific roles are, fee structures, payment terms, anything that just needs to be in a separate reporting to refer to within that contract. And we'll have some examples for those shortly. So this is the basic understanding of the contracts. So let's go and let's look at the three different types. Let's look at some real templates here. So the first one we talked about was the temporary staffing contract. So this is basically what it would look like. It would say the temporary staffing contract agreement is entered into on this day. So you put the date in here, and it's between who? It's between the client, and they are an entity of whatever state. This is important when something happens. Let's say you guys have to go to court and there's no arbitration clause. So the courts have to determine what jurisdiction, whose jurisdiction is this under? Is it under my state or is it under the client's state? So we're going to always state my business is incorporated in Florida, an entity in Florida, and its principal place of business is, and you'll put in their address, and then you'll do the same for the information for the staffing company. What this does is pretty much establish who the parties of the contract are, where they reside jurisdictionally. Then you get into services provided. This can be very long, but I kept it simple here just for the purpose of this conversation. The agency agrees to provide temporary staffing services to the client as described in Exhibit A attached hereto. Services provided, this can be very long. Terms of agreement. This agreement shall commence on start date and shall terminate on end date unless extended or terminated earlier in accordance with the terms of this agreement. See, this is only one sentence. That's the simplest form of a contract. This stuff must be there. And then everything else, you can make it as long as you want, but make sure that it's sticking to these basic structures. Fees and payment. A, the client agrees to pay the agency for services rendered according to the rates specified in Exhibit B attached hereto. B, all invoices from the agency shall be payable within whatever. It could be payable upon receipt, which is the same day. What we typically do with temporary staffing and direct placement is on the first day that that person starts, we're sending the invoice, and the invoice is payable within the 30 days. Sometimes we can make it payable within the 60 or 90 days to account for the guarantee, or we can make it due on the first day and pretty much late on day 31. Whatever your terms are, put it in the contract. C, late payments shall be subject to the interest rate of whatever percent per annum. I highly recommend having something like this in there to kind of, because you're going to have late payers. You're going to have those clients to where you have to hunt them down for your money. You're going to have some that pay as soon as they receive the invoice, even though they have 30 days maybe to pay it, they'll pay it as soon as they get it. But for those that are going to be late, you want to put some type of penalty in there so that that'll deter them from being late. Okay. Confidentiality. Both parties agree to maintain the confidentiality of all information obtained during the execution of this agreement unless disclosure is required by law. Please don't email me and ask whether or not disclosure is required by law in your state or whatever. I don't know. You need, that's the part that you need to find out, or your lawyer needs to find out, is what disclosures are required in your locale and the locale of your clients. Okay. What I said on the last video, general information is free or low cost. Specific information is neither free nor low cost. All right. So I'm giving you general information here. Termination. Each party may terminate this agreement within whatever amount of time you come up with, 30 days written notice. In the case of any breach of the terms of this agreement, the non-breaching party may terminate the agreement immediately upon written notice. Now, this whole termination thing, again, check with your state, because when it comes to termination in terms of labor laws and at-will employment, this can get kind of hairy because they don't need a reason to terminate the employee. Now, whether or not they terminate the contract with you, that's another story that you'll have to find out for yourself. We have indemnification. Both parties agree to indemnify and hold each other harmless from any claims, damages, or expenses, including reasonable attorney fees arising out of the services provided under this agreement, except to the extent that such claims, damages, or expenses are due to the negligent or intentional acts of the indemnifying party. I like to think of indemnification clauses as a sort of insurance, but forgive me if I'm using the term insurance wrong in these terms, but that's how I wrap my head around it. Like when we enter into this agreement, basically, I promise not to be overly litigious and try to sue you for every little thing. I promise to uphold my end of the bargain, you uphold yours, and we not end up in court over bullshit, basically, is what I see indemnification as. And if something does happen that is my fault, I'm not going to give you a hard time about making a claim to damages or expenses. That's the other part of indemnification. Relationship of the parties. It is understood that the agency is an independent contractor and not an employee of the client. Very simple. Neither party has the authority to bind the other to any third party or act in any way as a representative of the other unless otherwise expressly agreed to in writing. 8, this is a big one for you. Governing law. This agreement shall be governed by and construed in accordance with the laws of whatever state and country you're in. I don't determine that for you. You do. Amendments. This agreement may only be amended in writing and signed by both parties. Remember, I said at the beginning that so you can't give somebody the offer of this proposal and then they come back and it's all scratched through and written on and they've changed the terms of it. No, this is saying that if there's any type of counter or any addendums, any additions, any changes, it has to be changed in writing and agreed to by both parties. So if you're not going to do a counter offer or do a whole nother agreement or contract, then usually that's done in the form of an addendum. I'm adding something to this contract that wasn't already in there, and I need you to review it in the whole scope of the contract and sign this addendum so that it can be a part. It can be now become legally a part of the original agreement. Okay. Entire agreement. This agreement, along with Exhibit A and B, and any amendments or addendums, if you have them, constitutes the entire agreement between the parties and supersedes any prior understanding, written or oral, related to the subject matter of this agreement. Again, nothing outside of the four corners of this agreement matters. Okay. Then I mentioned earlier arbitration. This is dispute resolution. Any disputes arising out of this agreement shall first be attempted to be resolved through amicable negotiations. So let's talk about it. Let's see where we can get an understanding here. If the parties cannot resolve their dispute, they agree to submit the dispute to binding arbitration in whatever city or state under the rules of arbitration association. So some contracts don't have this. A lot of contracts do have it because it creates a barrier, a moat, if you will, so that you can't just go and bring this matter up in court. If there's some type of breach of this contract, you have to be able to show that you exhausted arbitration and other means before taking it to a court, right? Arbitration is court, but it's a little bit different than suing somebody, I guess you can say. Notices. All notices required or permitted by this agreement shall be in writing and shall be deemed delivered when delivered in person or on the third day after being sent by certified mail, postage, prepaid to the addresses listed at the beginning of this agreement or to such other addresses as either party may designate in writing. Force majeure. This is another favorite legal term. A hurricane is an example of a force majeure. Tornado. Neither party shall be liable for any failure to perform its obligations under this agreement if such failure is caused by acts of God, natural disasters, strikes, or any other event beyond reasonable control. Good example of this right now, in the pharmacist market, there are a lot of strikes going on out in California. I want to say Arizona, but there's pharmacists and pharmacy staff at certain big pharmacies are striking. So if pharmacists are striking and we have this contract, we can't sue each other because the contract failed due to strikes. It's nothing either of us could have done about it. Same with natural disasters. An earthquake happens. It's nothing we could do about it. Okay. So I couldn't go and sue my client because an earthquake happened, knocked down the building, and now my Christmas is ruined because I can't send my staff in as agreed. You can't, there's nothing that can be done about that. So this is the basis of the temp contract. And then you would attach your exhibits, the detailed description of services and the fee schedule. We'll get to that at the end. But let's go into the temp to perm employment contract. So much of the same. It starts out the same way, establishing who the parties are, when this was entered upon, and their locations for jurisdiction purposes. Temporary employment period, it calls that period out, but it also has a permanent employment period that it says upon the conclusion of the temporary employment period, the client may, notice it didn't say may, notice it didn't say will, it says may offer the permanent employment to the employee. The terms and conditions of such permanent employment will be detailed in a separate employment contract. Keep that in mind, a separate employment contract which may supersede the terms of this agreement. Compensation. So you would spell that out again. For the duration of the temporary employment period, the employee will receive compensation of whatever your rate is. And in the event of the permanent employment, compensation will be determined and documented in separate permanent employment contracts. So this has to do with your buyouts and your conversions. That's a separate contract. I think I have seen them combined in some ways. Some people have tried to combine them, but in my opinion, it may be easier to kind of do it this way, separate them out. Duties and responsibilities. The employee agrees to perform the duties listed in Exhibit A attached hereto, and the employee shall report to whoever the supervisor is and perform other tasks. Now, notice something. This was not in the temporary employment agreement, but guess what? It could be. So this is where I say a contract is what you make it. You can make it as long or as short as you want. You can add in whatever you want. So I would, take this part and add it into my temp employment contract as well. Termination during the temporary period. Either party may terminate the temporary employment relationship within X amount of days, 7 days, written notice. And same thing. What happens if there's a breach? There's confidentiality, governing law, the amendments, kind of repetitive, the entire agreement, and then you have your exhibits again. Now, direct placement agreement, more of the same, calling out who the parties are, where they're located. Services provided. You can put the services provided here, or I recommend attaching it in an exhibit. Reason being, if you have multiple contracts, it's easier to just create different fee schedules and different service provisions. For example, healthcare business is going to have a different rate sheet than how much I'm charging for engineers or whatever, like certain tech servicers. And I'll show you an example of that if we have time. For example, even though we talk about healthcare under one umbrella, the way that I do my pharmacist staffing is going to vary significantly to the RN staffing. Therefore, I would have two completely different fee schedules sometimes for that. Like I may have a fee schedule that only deals with pharmacists and the circumstances under which I would be staffing a pharmacy. Fees and payments. Again, we have that here. The guarantee. Now, this is where it's important. The guarantee again is how long am I saying that this person has to stay on with you? We mentioned a guarantee on the temporary side, but the guarantee is more important here on the direct placement side, because what is the warranty on our person that we're sending in? How long at minimum are we guaranteed that they're going to stay and perform well for our client? And then what happens if they don't? What are we going to do? Refund them or send in somebody else? So you have to call that out. Then you have confidentiality, termination, indemnification, relationship of the parties, governing law. All of this is repetitive, right? So see, not too hard. Now let's look at our exhibits. So exhibit A, detailed description of services. So I just made up this one for the purposes of this lecture. Temporary healthcare staff and services. So I would put what the job is, the scope of the services, like what is the person, what is the staffer going to be doing within the scope of providing that service for a pharmacist. What are their required qualifications? So what am I guaranteeing to my client that this staffer is going to have? This can be way more extensive depending on what it is. But for the sake of this, I kept it real simple. Then you have registered nurses, licensed practical nurses, respiratory therapists, home health aides. I just threw that in there because home health aides and homemaker companions, that's treated different for the most part. Like that's a totally different business, definitely a different line of business. But I threw it in here just to add some meat to the conversation. So that would be that exhibit, which is your exhibit A, detailed description of services. Then exhibit B is your fee structure. These can get extremely detailed. So for temporary healthcare staffing fees, how much am I going to be charging for my pharmacist? What's the overtime rate? How much are the nurses? How much are the LPNs? How much are the respiratory therapists and the home health aides? Like how much are we going to be billing you per hour for them? Now notice something. We just put an hourly rate in there. Let's just say it's $75. You would not put how much you're paying your person. In my opinion, that's not the business of the client. The client needs to worry about how much you're paying the client. Now, I have had instances where the client asks the person or finds out how much we're actually giving the employees. But that's outside of the contract. That's outside of the four corners of the document. So if you agreed to 75 an hour, if I'm paying the pharmacist 60 an hour or 50 an hour, that's my business. So what you're putting on this fee schedule is how much you are charging the client, not how much you are paying your pharmacist or your registered nurse. Please make sure you understand that. Okay? Because just make sure you understand that. And then you have the additional fees and terms, like the conversion fee. If the person, this one trips everybody up. I don't know why. It ain't nothing but a sentence. The conversion fee. If the client should wish to permanently employ the temporary employee provided by us, the recruitment agency, there's a conversion fee of whatever percent of the annual salary offered. So maybe that's what messes people up, is knowing how much to charge for the conversion fee. I don't want to throw a number out there because that's going to be dependent on your locale. Same way I see everybody, I could tell kind of who hasn't really made placements because everybody wants to say 20 and 25%. Like that's the standard. Like, yeah, I'm charging 20, 25%. When in actuality, these companies these days are kicking you back like, I'm gonna pay you 10% or I'm gonna pay you a flat fee. Depending on what the salary is, they're paying flat fees for some of these direct placements. So it's not always going to be 20 to 25%. So you need to know what your market is and what are the conversion fees and the markups and things look like in your area, because it's not always going to be 25%, 30%, 20%. That sounds great, sounds ideal, but if you're really working this marketplace, you'll know that flat fees are way more common, especially on the contingency side. When you get into retained and executive search, then you're charging 25, 30, but that's because you have established yourself as a person or an agency that has earned the exclusive business of that client. Most of you starting out are not starting with retained and executive exclusive searches. So you're going to have to go with whatever the market dictates. There's a cancellation fee, which this one is important. I've had this one happen a couple times. If we confirm dates, say for instance, I have to send a pharmacist to St. Augustine for the week of Thanksgiving to cover one of my clients. So we've already agreed to that, me and the client. So it's a go. But let's just say that client needs to cancel. Well, they need to cancel within a certain amount of hours or days before the start of that week. Or I'm going to charge them maybe for one day. So if my person is prepared to go to that pharmacy Monday through Friday of that week, having Thanksgiving off, and on Sunday night they say, oh, never mind, we don't need them, I'm going to charge them for Monday. I'm going to send them a bill for one of them days, so you determine how you're going to do that. Travel and lodging. I'll give you an example. Travel nursing, they get paid all kinds of fees, but on the pharmacist side, typically the client, and not every client now, pays for travel and lodging. If you can negotiate this, great. Some don't do it. I have a long-term care client that doesn't do it, so I'm only gonna staff people who are in the area. It's no point in sending somebody that needs to stay overnight. But if you have a client where you can negotiate travel and lodging, they may be able to get reimbursed for mileage. So how we do it is, if a person is traveling more than 50 miles from their home, beyond the 50 mile, if it's 51 miles, they get the standard deduction, which is the federal deduction. I think it's 66 cents. It was 63. I think it's 66 cents now per mile. So if it's 1 mile over, they get the whole amount. If it's 1 mile less, if it's 49 miles, they don't get the travel, the mileage reimbursement. And then depending on how far they're going, they get one night's hotel stay, or, depending on how many days they're covering, would determine those expenses. But those expenses have to be pre-approved by us and the client. Billing and payment terms. Invoices will be issued on whatever basis, weekly, bi-weekly, monthly. I see a lot of monthly invoices, even though, in my opinion, it's easier to do them weekly and bi-weekly. Some of my clients, we send invoices for the month, and it's fine. And they're payable within a certain amount of time, 30 days, 60 days, whatever. I highly recommend 14-day, 30 days max for your payable within invoice date terms. And then, of course, I mentioned the late payments, there being a percentage for late payments to kind of deter them from that. And then all applicable state and federal taxes. That's for you to find out. So yeah, this is all of this document. Now, I did mention that I was going to go over some of the other documents that I have. This would be enough for you to get your documents together. But just to show you, which one did I want to look at? Oh, this is a good one. The agreement to supply tech personnel. So this is a more extensive one, but you can just look at what it says here. And this is just for the purpose of getting an idea of how extensive these contracts can be. And and this allows you to look at all of these and basically be able to pull in to your contract what it is you can use. Take what you can use, discard the rest. So this is a good agreement. This one includes the insurance and liability, workers' compensation, and all that type of stuff. This is good to have, especially on the staffing side. Your workers' compensation and all that, go back and look at my last video where I talked about the insurance a little bit, because that's going to vary based off of your classification of your workers and your location. So this is a pretty good contract. I got this from the American Staffing Association, so you might want to go over there and see what resources they have. But this is a pretty good contract. And then it has, and their exhibit is confirmation letter. Yeah, this is pretty good. Let's look at another one, because there was one that I wanted to show you. I don't know if I have it in here. Let's see if it was this one. They had an extensive service, like the call out of the rates. It was really good. What was this? Model recruiting agreement. This is American Staffing Association also. Yeah, you definitely want to go over there and take a look at this. This one is way more extensive. What I am looking for is the one that has the rate sheets. But yeah, this is a good agreement as well. This one has something in there about background checks and everything, waivers, refunds. So this can get, really detailed. But this is free if you go to the American Staffing Association. To my knowledge, you can go download this. Maybe I don't have the agreement that I'm looking for. Let's see, the secondary suppliers. Let's see something. This is from Kelly Services, one of the largest staffing agencies. If anything, I would love to model myself to be like Kelly Services. This is their secondary supplier agreement. Pretty extensive. This can be found on the internet as well. Theirs is 27 pages long. So if you're going to be doing something like a labor type thing where you're doing more the low paid roles by volume, this is a very good contract to look at as far as their attachments and exhibits. Um, Still not seeing the pricing. Yeah, I don't think there's a particular contract that I'm thinking. Actually, this is similar pricing of services. This isn't the one that I was looking for, but you see how they have it called out how much their various personnel cost and what the multipliers are and all of that stuff. You want to go and find these contracts. Some of them are just hanging out on the internet, and you can just get an idea of what to incorporate on yours based on the services that you are offering as compared to these. So if you're staffing teachers or whatever, labor force, this might be a good one to look at. I do not see that contract that I was thinking of. I got a lot of them in here, but maybe I'll do another video at some point, because there's one that is extremely extensive, and it's actually a government contract. You know what? I think I probably deleted it out of here because it was so extensive. I didn't want to confuse anybody. Um, as a matter of fact, I know where it is. Let's go into the scale your agency. It was so extensive that I'm like, no, this would be for somebody that's trying to scale. So it was a state contract. Yeah, these government state contracts, baby, they get heavy. And the reason why I have them, since I'm not working with them anymore, I used to be a contractor for US Tech Solutions. So you see here, this contract is 244 pages. So when I tell you, and this is for staff augmentation. So staff augmentation, this is something that Care Dynamics offers. But what staff augmentation means is that, let's say a big PBM company is doing a data migration or for welcome season. So they will literally, whoever their employment vendor is, if it's my company, they'll literally reach out and say, hey, I need 50 pharmacists to start on next Monday or start the Monday after Thanksgiving. I need you to train them and deploy them. That's a big augmentation to make something bigger. And what that does is that team of the 30 to 50 people or whatever, that team comes in and acts as an extension of their existing staff, their existing team for a specified period of time, whether it be welcome season or whatever big project that they have. So this is a information technology staffing augmentation contract with the state of Florida. And these exhibits are really extensive because you see here, it gives you all of the pricing. So these are all the people or the type of requisitions that they're able to deploy for any given project. So you could have a project that needs one of each of these or 5 of each of these. And these are a hell of a lot of roles. See? So you would call it all out this way. I didn't put this in the other folder because I'm like, you know what? I don't want to intimidate somebody, but it can get real intricate. So maybe sometimes you guys are looking at this type of stuff and thinking that you need that to start your business. You don't. It's unlikely as a beginning agency that you're going to do any big augmentation projects. But staffing augmentation is something that we're able to do because we've done it. So, but this is the contract that I was looking for. You see how extensive this thing is. Very, very, and this is government. So this is another reason why it's extensive, which brings me to another point that's beside the point, but a great point to bring up. You can get a contract with your state. You can get a big contract with like Amazon, which is privatized, non-government, but I won't say the same thing, but as extensive. So when you get into these large projects and these large vendor assignments, because you would be the vendor, when you become a vendor for these extra large organizations, this is what your contracts are going to look like. Like their exhibits, they have family descriptions for all of those jobs that you saw. It's all in here. So your contracts can be as simple as what I initially introduced, or they can be as intricate as these government contracts. And this is aspirational. This is where maybe we all want to aspire to get into. And without me saying too much, this is definitely the direction that I'm going on some initiatives that I have. Um, yeah, I won't. Well, I can talk about them because it's not like you can just go out and do it. But a couple of things that I have undertaken recently for Care Dynamics is second chance employment, which is employing and staffing the justice impacted community, and then refugee and immigrant staffing, some DEI, diversity, equity, and inclusion placement. And when you get into those type of initiatives, your contracts are going to look kind of like this. This is their one pager. I recommend having something like that for your business. Their letter of interest, executive summary. Matter of fact, I just did one of these proposals the other night. I can't show it to you because I can't reveal who it was for. But yeah, when you get into writing the big proposals, this is what your contracts are going to look like. So we're almost at an hour. So I'm going to go ahead and end. Let me click on one more though. Hold on. Because this is good stuff. This one, I do not remember who it was for. Well, it says it there, but here's another price sheet. There's an Excel spreadsheet format. So what you can do is you can make something like this a part of your exhibits. When you determine how much you're going to pay for every requisition that you're offering, you would send this over. You would have your contract, and then you would send something like this over. And you see here, this is all the requisitions and roles and what they charge, what the bill rate is, what the markup, and all of that. So you may have companies that require you to submit something like this too. So I hope this foray into contracts has been helpful for you. Here's more exhibits about job titles and descriptions. So I have all this stuff. All of this stuff is a part of the digital toolkit. Now, before you guys email me asking for the digital toolkit is not free. It's not free, but I've given you more than enough information right now to go and create your contracts. If you need anything that is here, the link to purchase the toolkit will be in the description, as well as the link to book a one-on-one with me if you determine that you need one. So that being so, I'm going to go ahead and sign off now. And I thank you for tuning in. I hope I did not lose you. I hope I provided some clarity around contracts. But as always, if you have questions, feel free to reach out. Keep in mind that general information is free and low cost. Specific information is not. So when you're reaching out, bear in mind as to whether or not your question is general or whether or not it's something specific and you need to book a one-on-one. I don't want to have to be the one to tell you. So use your judgment when you're reaching out, because I do have a lot going on, but I am willing to assist. So thank you very much and have a great time.